Hello, everyone, and welcome to our webinar today. My name is Anna Kuzin, and I'm a program assistant here at the Justice Programs Office at American University. Before we get started, I'm going to go over how the webinar will work today. All attendees are currently muted. If you have a question for our panelists or for us throughout the webinar, please submit it using the Q&A panel located on the right side of the webinar screen. Your questions will only be seen by me, and hopefully we will have a chance at the end of all of the presentations to ask our presenters some of the questions that have been submitted. If you would like to make a consortium member update after our panelists present and after Q&A, please use the chat function to message us so that Genevieve Citron-Ray can read your announcement out to everyone on the webinar. If you experience any technical difficulties during the webinar, feel free to message us using the Q&A or chat function. At the conclusion of this webinar, a brief survey will appear on your screen, and we would appreciate it if you could fill it out as it helps us improve our future webinars. And as a final note, this webinar is being recorded and will be posted to the Justice Programs Office YouTube channel and website. I'm now going to turn it over to Genevieve Citron-Ray.
Thank you so much, Anna, and thank you all for joining us today for our quarterly webinar. We're really excited to kick off our Real Talk series. Today will be the first of them, called Real Talk with Former Defenders, continuing to champion the right to counsel and alternative rules in the justice system. So today, I'm really excited that we have Judge Betty Thomas Moore from Shelby County, Tennessee, and Seema Gajwani from the D.C. Office of the Attorney General, and our very own Zoe Root from the Justice Programs Office. And they are all former public defenders who will talk about how they have continued their role as champions of the right to counsel in different capacities in the justice system. We will hear from them about what led them to become public defenders, why they decided to change careers, and what they currently do in their roles to ensure the right to counsel. Following the three presentations will be some Q&A. As Anna indicated, please, throughout the presentations, if you have questions, you can use the chat function and address it to all panelists. Following that, we will have consortium member updates, which will be led by April Frazier Camara from the National Legal Aid and Defender Association. Also during that time, if you have announcements that you would like to make, please, again, use the chat function, and we will make those announcements at the conclusion of the event. So without further ado, I'm going to turn it over to Judge Betty Moore.
Bye. Thank you. Hello, everybody. Thank you so very much for having me here. Can I have that first slide, please? I am just honored to be invited to participate in the webinar. Most certainly one of the things that is so most dear and near to my heart is the right to counsel issue. I am here in Memphis, Shelby County, Tennessee. I am a judge in General Sessions Court, and I have been sitting as a judge for the past 18 years. I am working on my third term here. But I come from a public defender's background. I worked with the Public Defender's Office as an assistant public defender here in Memphis, Shelby County, for about 15 years before I was elected to the bench in 1998. A little bit about myself: I am a native Memphian here in Memphis, but I also graduated from the University of Memphis Law School. When I went to law school, one of my dreams always, even as a child, was to become a public defender. I always wanted to be a champion, so to speak, of those people who didn't always have access to an attorney or had their rights protected by a lawyer. And I wanted to be really good at what I did as an attorney. And I thought being a public defender, that's what I want to do. That's somebody who works for and fights for the underdog. And so when I went to law school and as I began to practice in the public defender's office, I got the feeling that public defenders didn't have very good reputations, whether deserved or not. And my desire was to make sure that I was one of the best lawyers handling cases for the public defender's office. And so I did all kinds of cases, of course, as public defenders do. And I have to say that here in Memphis, our public defender system is one of the oldest in the country. And so we have a pretty good public defender system. Our public defenders are assigned to every courtroom that we have. And so our defendants here have access to a lawyer at just about every stage of the proceedings because someone is there, even during arraignment. Now, as far as when they are arrested and prior to being arraigned, there is no access to an attorney at that time, but from the stage, once they get to the courthouse doors, then they have access to a public defender. I will also say that as in other jurisdictions, we also have in place where if there's a conflict with the public defender's office, then we do appoint private counsel to represent individuals, and that has expanded because at one time it was just a little bit of the public defender and a little bit of appointment. And so when I became a judge, I wanted to extend that desire in my heart to make sure that the right to counsel was protected. Can I have the next slide? Now, I love this cartoon, and it speaks to exactly what I think a lot of judges, not just here in Memphis and Shelby County, but a lot of judges all across the country sometimes have felt like either in the past or sometimes maybe in the future, right now in the present. Right to counsel. He hates it when lawyers quote the Constitution. And I think that sometimes that is because a lot of judges don't want to be told what to do. Maybe our priorities are not exactly where it needs to be as far as making sure that defendants that come through our court system have equal, fair, and access to justice, i.e., an attorney at every stage of the proceeding. And we've read it. I mean, we hear about what happens across the country with attorneys being appointed with public defender systems. We all know that many public defender systems are overloaded. Lawyers are underpaid. It's just not working. Many of you may very well be aware of a situation where in Louisiana, a judge decided that, you know what, this is too backed up. The public defender's office can't handle all these cases. And the judge decided that he would dismiss about 7 cases of defendants who had been in jail for so long, had not been appointed an attorney because the public defender's office was overloaded. Didn't let them out, but he was making a statement. We've got to do something to ensure that litigants have a right to counsel at every stage of the proceeding. If that doesn't happen, then the whole system does not work. But I think that a part of the problem has to be the public's perception, too. We have to let people understand and know that the system only works when everybody's protected, not just victims, not just the prosecutor's office who's given tons and tons of money and resources to do what they need to do, but defendants' rights need to be protected, and the public defender system, attorneys appointed, need to be funded and financed the same way as the prosecutor's office. Let me have the next slide, please. So we already know about what right to counsel is all about. You have defendants who come in and, you know, the case goes all the way up to the Supreme Court. And so when it goes up to the Supreme Court, that tells you that somebody had to be told from a lower level all the way up that, hey, there needs to be an attorney appointed to individuals who come through the system. The system needs to be not only look as if it's fair, but it actually needs to be fair. The Supreme Court says that no one may be imprisoned for any level of crime without legal representation unless the accused has knowingly and intelligently waived their right. And we already know that that often does not happen. How can an individual who comes through the system who does not have the intelligence or the knowledge or the educational experience to knowingly and intelligently waive his or her right? Well, you know, they have a right to say, I don't want an attorney appointed, I don't want a public defender. But the bottom line is that it's the judges. It's our job to ensure that there is a counsel, that there is an attorney appointed, and that if a person just has to insist that he or she is not going to have an attorney, ensure, ask all the right questions, do all the right things to ensure that not only are their legal rights protected, but if you don't want an attorney, okay, fine, but I'm going to make sure as the judge that you knowingly and you intelligently, whatever that level may be, waive your right to have an attorney. But that attorney is going to be there and available for you. So the Sixth Amendment right to legal counsel occurs at every critical stage of a criminal proceeding, including during the investigation, at hearings, and during the trial. That doesn't always happen. It does not happen in many, many jurisdictions. And so we have to, as judges, and most of us, I believe, do, we insist on that as much as we can, recognizing that a public defender system especially is stretched to the seams. Lack of money, lack of lawyers, lack of resources. And so it's our job as judges to ensure that that happens. Critical stage, and my screen went out. Critical stage is any step during a criminal prosecution where the accused's rights may be affected by the absence of legal representation. So if we appoint the public defender or an attorney at the very beginning, then to me you don't have to worry about all that, because then you're covered. You're covered. And so we judges have to get on board of this right to counsel, and some of us are, and some of us aren't. And so I am so happy to be a part of a program that encourages judges, more judges, to get on board. You know, it's important to our system of justice. Next screen, please. Next slide. Funding of counsel, and this is what I talked about before. Even with the cartoon, if you cannot afford a lawyer, the trial will go a lot faster. You know, I like to add a little humor in it because sometimes it can be so humorous that it gets to be ridiculous. Because, you know, you have the right to an assistance of attorney. Most people who come through the system, we already know, they can't afford lawyers. And we have to appoint attorneys, we have to pay for the legal defense, and we have to get our legislators in every jurisdiction on board to understand that the monies have to be provided to ensure that justice is served. And unfortunately, as you already know, a lot of jurisdictions, funding for the right to an attorney is the last thing on the list. It may get done, it may not get done. And so besides getting those of us who work in the legal system on board, we must get our legislators on board to fund attorneys for individuals who can't afford a lawyer. Next slide, please. So that's just a summary of what the right to counsel is. But the one thing that I want to touch on with this last slide is the third bullet point. Every lawyer has an obligation to do everything legally permissible to see that the client's rights are upheld. Right to counsel doesn't mean that you just provide the money and the body, the attorney, to represent an individual. You provide the lawyer who has not only the legal knowledge and the abilities, but the heart to do everything that is legally permissible to ensure his client's rights. We've got to do that. We've got to have not only that desire, but we have to have that commitment as legal representatives, whether you are an attorney, whether you are the judge, whether you are our legislators, to ensure that this system of this judicial system, this system that we have in place survives, and that it doesn't survive at the very minimum, that it survives at the highest level to ensure that all of our systems, whether you are a victim or you're a defendant, that all of our citizens' rights are protected and that they're given every right that's afforded to them by the Constitution. Thank you.
Thank you so much, Judge Betty Thomas Moore. It's really wonderful to hear how impassioned you are and how you continue to be a champion of the right to counsel. And I also really just appreciate you highlighting at the end there about how it's not just on one of us to push and advocate for change, but everyone can play a role in ensuring the right to counsel. So with that, I'm going to turn it over to Seema Gajwani.
Hi, thank you so much for having me. It's great to be on this webinar with Judge Moore and with the whole staff. I'm really honored to be asked, so thank you. I'm going to just speak for a few minutes about my career trajectory. My name is Seema Gajwani. I work at the DC Office of the Attorney General. My job title is I'm Special Counsel for Juvenile Justice Reform here at the DC OAG, and I advise Attorney General Karl Racine on juvenile justice reform matters. You can go ahead to the next slide. So I started my legal career after law school at the DC Public Defender Service, which was, you know, an honor for me and the dream job that I had wanted for most of my life. At PDS, where I was for 7 years or so, we start for the first year representing juveniles. Currently, I work at the office that prosecutes juveniles. But back in 2001, when I graduated law school and started at the DC Public Defenders Service, I started my career representing youth who are charged with crimes in DC. Our office, the Public Defender Service in DC, for the most part, takes the more serious offenses. So on the juvenile side as well as on the adult side, we typically don't take misdemeanor offenses as a statutory matter. Our authorization enables us to take only the more serious offenses, so typically felonies and above. After spending about a year in juvenile court, we move up to an adult caseload that starts out with guns and drugs cases. And then over the course of my time at PDS, I continued to move up and then handle jury trials. I had a large docket of Title 16 cases, which means I represented the youth that were being charged as adults in adult court, in jury trials, and then co-counseled a series of homicide cases before I left. You can go on to the next slide. Like Judge Moore, I had always wanted to be a public defender. So when I was in high school, I did a short internship with a criminal judge in Miami, Florida, which is where I grew up. And I was just fascinated by court and by trial and by the whole experience, and immediately decided that I wanted to be a public defender. Representing people who were considered the least kind of worthy in the courtroom setting, and also, it seemed, in society. I thought that that was a critical and important and noble thing to do. The judge that I interned for had been a prosecutor, and he counseled me to go work in the Miami State Attorney's Office as an internship, and so I did that. But felt even more strongly after that experience that I wanted to be a public defender. At the Miami State Attorney's Office, I did glorified secretarial work. I would help write warrants and interact with detectives and police officers, and remember feeling just horrified at the way that they would talk about defendants and even witnesses in crimes, and the tactics that they would use to try and intimidate people, especially the most vulnerable people in Miami, who were typically people who had fears of immigration deportation, and the way that they would laugh about, frankly, about kind of intimidating and terrorizing them. So that made me even more convinced that these are folks who needed protection, and in our justice system certainly we're going to be vulnerable, and I wanted to be the one who was helping represent them. So I continued to work in various different internships around criminal and juvenile justice issues. You can go back, you can go another slide ahead. I did, however, when I was at PDS, I did kind of long to work on more systems levels and impact policy. I think everyone on the call and anyone who's worked as a public defender, I think, has had those experiences where you feel like you are working tirelessly to help an individual and that person's family and their community to the extent that representing them in their case will be supporting them and their families. But there was this definite sense that the system was stacked against them and that these laws were unjust, even in an environment like in DC, where you had a strong public defender with a lot of resources and with the support of investigative staff and an appellate division that could help you appeal your cases if need be. And even staff that could work on the other issues facing clients, including civil and other matters that were increasing the burden on them at a time when they really needed to focus on their trial. And so I kind of got involved at PDS in some kind of systemic issues around eyewitness identification policy and kind of on my own time, like did research on those kind of things that were more systemic and impacted the entire justice system. And at some point I was lucky to have a job opportunity, a job announcement kind of pass through my desk. And as a public defender, you're so busy that oftentimes those things just seem like impossible tasks. You've got trials scheduled and you've got all this work to do and meetings with clients at the jail and family members in the community and witnesses and victims, and to sit down and think about what you would say to apply for another job seems like an insurmountable thing. And so I thought about it when I saw that position description and then promptly forgot about it. But lucky for me, the person who had circulated that job announcement, who worked at PDS, who's our wonderful Jen Thomas there, circulated it again and encouraged folks to apply. And so the second time around I did. And I did because the position description working at the the Public Welfare Foundation was for somebody to think about how to use philanthropy and funding streams to help reform the criminal and juvenile justice system. And they specifically said that we are looking for somebody who is willing to talk to advocates and experts and researchers around the country to learn about the best way to use funds to bring catalytic change to these systems, which, seemed incredible. And so I applied and I got that job, which was, again, just miraculous and very exciting, and had this incredible opportunity there to shape a new program around juvenile and criminal justice. And for the first several years, I worked on both criminal and juvenile justice. The program was really successful. We had an annual budget of $5 million to spend, and after a few years, they decided to break that up into two separate programs and increase, more than doubling, the funds dedicated to criminal and juvenile justice. And they created a separate criminal justice program and a separate juvenile justice program, and I took the criminal justice program. This was just an incredible experience for me because I was just allowed to explore and learn about how systems worked and where levers could be pressed for change and what are we looking for in change. The overall kind of goal of my portfolio was reducing mass incarceration. And on the criminal justice side, I worked specifically on sentencing reform, pretrial and bail reform, and ultimately on prosecution reform. One interesting anecdote is that when I went to public welfare, having been a public defender, what I thought would be valuable about my prior experience as a public defender, it turns out wasn't as valuable, and there were other things that I found to be more valuable. So one thing that I thought would be valuable was the experience of having worked directly with clients and their families and communities, that would give me insight into the work that I was doing, and it certainly did. But what I learned when I kind of got into the systems reform field was that a lot of the players who work in criminal justice and juvenile justice systems reform have a lot of that experience, having worked directly with, having been impacted themselves by criminal justice systems, having family members or friends who've been directly impacted. And so there wasn't a lack of that I needed to kind of bring to the conversation. There was plenty of that, and in many ways more authentic and credible than my experience having only represented individuals in the justice system. What was really valuable, I think, in retrospect, was the experience of having been a public defender, because as a public defender representing an individual who was charged with a crime, what became very clear was the instinct to win and to figure out how to win in whatever way that you could. And, before a jury, you have to convince people who may have very different worldviews You'd have to convince people who have preconceived biases and stereotypes that your client is worthy and valuable. In front of a judge, in negotiating with prosecutors around mitigation or in plea negotiations, you have to figure out a way to appeal to them, all of them, in a way to win for your clients. And the goal was to win, to the extent possible, what your client wanted to get out of the system and to get out of their case. And I think that it was kind of like a very acute focus that stayed with me doing policy reform. And what I found sometimes in the policy reform field were people who were very focused on kind of the principles and being right and getting the kind of perfect outcome, and even compromising on some potential wins early on, with the goal of kind of being proven right and getting the perfect win. But I knew that as a public defender, you know, my client who I stood next to, who was facing terrible sentencing laws, needed immediate relief. And I think that was kind of one of the driving things about my work there. And it made me very, very action-oriented and less kind of ideological, I think, than maybe some other folks, mostly because I would always think about my clients and how they didn't care if we won on principle, and they didn't care if we got 100% of what we wanted. You know, getting relief was the most important thing for them and their families, and that kind of guided me. You can go to the next slide. So what I work on in the Office of the Attorney General right now is juvenile justice reform. And I recognized when I was looking to leave the Public Welfare Foundation, and I saw the opportunity to work for a newly elected, or actually at the time, somebody who was campaigning to be the Attorney General. Our office handles all of the juvenile prosecutions for the district and a small subset of criminal prosecutions for Washington, D.C. The Attorney General himself has never been a prosecutor. He has a background where he had also worked at the Public Defender Service for a short time, and is a very progressive person. And I knew that he was really committed to progressive reform because that's how he campaigned. He talked a lot about the school-to-prison pipeline and juvenile justice reform, and I believed in him and his kind of political courage to take on these issues. I also recognized, having, again, worked on systems reform at the Public Welfare Foundation, having funded lots of efforts to change sentencing laws and to work around advocacy and do all sorts of reforms, that at the end of the day, if you can't change the prosecution function, there's always going to be an end run around reforms that will allow prosecutors and sometimes judges to sentence people the way that they want to. That just became enormously clear to me over my time working at on systems level policy, that the most powerful entity in the justice system, the one that for the most part drives mass incarceration, and that's also arguably the least transparent, is the prosecution function. And I thought a lot about how to affect that and change that, and we started a program to a part of our portfolio to impact prosecutorial culture and to elevate some of the newly elected urban prosecutors and think differently about the way that they see their roles and what it means to be accountable to communities, certainly urban communities, as a prosecutor. And so in this job, I felt like I had an opportunity to think about how to actually implement that and see if we could try and move a system and innovate and be a model for a different type of prosecutor. And that's what I get to do every day, which is fantastic. I feel incredibly lucky in this position. One thing I remember somebody saying to me, a friend of mine who was another funder, he had worked for Kamala Harris, the district attorney of San Francisco, for many years, and he was a high-level advisor to her at some point, and he said to me, Seema, we would hire good people to be prosecutors. We hired civil rights-minded folks. We trained them well. who talked to me about their training program. But he said, you know, after years of working as a prosecutor, they would change, and they would become punitive and tough on crime, and it didn't matter who they were before. And so I've thought a lot about that while at public welfare and a lot in my current job about how do you change the culture of a prosecutor's office to be respectful of procedural rights of indigent defendants, to recognize the communities and the systemic barriers that they face. And so that's part of what we're doing here. And in fact, one of the many things that we're trying to work on is, in addition to kind of like the programmatic stuff, is culture change. And so we've done a lot of training for our prosecutors on implicit bias and adolescent brain development and trauma-informed care. And one of the things we hope to start soon, and this is through our Restorative Justice program, which we're also building here, is a way that prosecutors can spend time regularly in schools in the district listening to students talk about their lives and talk about violence and how it affects them. And interestingly, just this morning we had a group of 15 or 20 students come from a public high school in DC to talk about some policy stuff that they were working on at a project, and one of their teachers asked if they could come in and talk to us. And what we did was we created a circle, and we asked them about violence and how it impacts them, and risk and consequences and the things that they experience and how they try to diffuse violent situations or walk away from situations that can be violent. And we did a lot of letting them talk to each other and talk amongst themselves in the circle, and it was fascinating. And they were incredible when they kind of were clear that this was a safe space and they were allowed to be honest about these things. And what we hope to do is expose our prosecutors to that kind of environment pretty regularly so that they can kind of see what kids deal with in their lives, understand a background and an environment of school and life that is very different from the backgrounds of most of our prosecutors, and also see thoughtful, productive, successful, and kind young men and women in a setting outside of the justice system where they can talk about the struggles that they're going through. So anyway, that's one of the things that we're trying to do around changing culture of prosecution. On the programmatic side, we've done a lot about changing our policies on discovery and Brady and diversion and off-ramps and various different manners. Our boss, the Attorney General, waged an effort to address the shackling of youth in court, and that was successful. And we continue to monitor that because there's slippage sometimes. The last thing that we're working on is real violence reduction and prevention efforts in the community. You can go to the next slide. And that's in part because when we go into communities and when we talk to victims and offenders and their families through our restorative justice conferences, what becomes very clear is that they're appreciative of systems reform, they're appreciative of diversion opportunities, but the impact of violence in their communities is dramatic and is of utmost concern to them. And what I felt like when I was working at public welfare on a lot of the systems reform work was that you can change sentencing laws, you can try and change culture, you can change a lot of different aspects of the system, but if crime goes up, that stuff becomes very, very vulnerable. And and there are strategies and tools that are deeply empowering to communities to address violence within communities, using individuals who've come back from prison, using individuals who've been through the justice system to help cultivate positive interactions between people, diffuse systems, prevent retaliation. And we believe, and my boss, the Attorney General, believes that if public safety is an issue that he is charged with, then violence prevention is certainly on the table. And so we are building out a program to address violence prevention in communities because we believe that that is also an important aspect to justice reform and protecting reforms that we can make. And the last slide, so I'll just end by saying that I still kind of wince sometimes when I tell people that I work at the prosecutor's office, and I feel that everything I do is really in large part guided by my experience working at the Public Defender Service and working with clients directly. And I still find that, certainly through our Restorative Justice program, that's my favorite part of my job every week is when I get to work with youth and their families and in those conferences. And I think that's because that was my favorite part of being a public defender. So thank you.
Thank you so much, Seema, for sharing your story with us and giving us this very full perspective, that started out as a public defender and then fighting for system reform and then going all the way through to kind of system implementation. It's really great to see people like you now trying to push through some of those reforms that you helped to cultivate. And last but certainly not least, I'm going to turn it over to Zoe Root from the Justice Programs Office to talk about her experience. Zoe.
Thank you, Genevieve. Well, first let me just say that I am so honored to be able to share the virtual floor, so to speak, on this webinar with both Seema and Judge Moore, two incredibly fierce women lawyers who I deeply admire. So my name is Zoë Root. I am Senior Policy Counsel here at the Justice Programs Office at American University. Before I took on this role, I worked as a public defender at the Bronx Defenders for 5 years. So why did I want to be a public defender? Well, so I, like both Seema and Judge Moore, I always knew I wanted to be a public defender. I grew up in New York City with a father who is a public defender, and I learned at a very young age that the criminal justice system is a place where, it's a deeply dysfunctional place where very bad things happen to very good people. And I was sort of raised with the mentality that it was my job to do whatever I could to change that. So after college, I went on to work at an organization called CASES, which is the Center for Alternative Sentencing and Employment Services in New York City. It's an alternative to incarceration for juveniles who are facing the potential of detention because they've been charged with felony offenses. And in that role, I was able to advocate for youth in both Supreme Court and family court to be released from jail or detention and sent to the CASES program instead. And in that role, I was able to see not only the dysfunction of the criminal justice system firsthand, but also the incredible difference that community programs can make. And I knew based on that role that I wanted to go to law school so that I could fight for my clients in all phases of the criminal case, not just to get them into a program. So from CASES, I went on to go to Northeastern Law School in Boston. And Northeastern is a public interest-focused law school that provides the opportunity to do 1 full year of internships, or as they're called at Northeastern, co-ops. So I got to co-op at a variety of places focused on the criminal justice system, including the Bronx Defenders, which was my dream job office. And after going to Northeastern, I was fortunate enough to go on to work at the Bronx Defenders. The Bronx Defenders is a public defender office in the South Bronx, and it uses a holistic model. And so what does that mean? That means that at the Bronx Defenders, they recognize that each client is a whole person with a variety of needs resulting from their involvement in the criminal justice system. and often you'll hear those other needs referred to as collateral consequences. But at Bronx Defenders, we thought of them as anything but collateral. So in addition to having a criminal attorney, all of my clients were entitled to a social worker, to an investigator, to a family court attorney, to a civil attorney to represent them in housing court, and an immigration attorney to help them navigate the many systems in which they were entrenched as a result of their involvement in the criminal justice system. And the Bronx Defenders was an amazing place to work, and the work was really hard, but it was also incredibly rewarding. It's an incredible privilege to be able to hold space with a person on one of the worst days of their lives and to hear their story, and it is an awesome responsibility to then communicate their humanness to players in the system that are programmed to perceive and treat that person as less than human. So why did I leave? Good question. It was really hard. Throughout the time I was at the Bronx Defenders, I got to work as a staff attorney, a supervising attorney, and as the director of the Prostitution Conviction Vacature Project, which is dedicated to helping victims of sex trafficking vacate convictions from their record. And while at the Bronx Defenders, I represented thousands of clients charged with everything from hopping the turnstile to attempted murder. And for almost all of those clients, I witnessed the ways in which the pernicious and systemic racism and classism and sexism and homophobia were inextricably tied to their involvement in the criminal justice system in the first place. And just as Seema discussed as well, this is a really hard thing to see on case after case, and it's a hard forum to work on these issues when you're in the courtroom every day, because oftentimes a discussion of the systemic issues that brought your client into the system in the first place are not a welcome topic of conversation in the courtroom. And often those conversations would get shut down, and I felt very motivated and dedicated to figuring out a way to address those systemic inequalities that are deeply entrenched within the system. And that's why I feel so lucky to have gone on from the Bronx Defenders to the Justice Programs Office here in Washington, D.C. The Justice Programs Office is a center at the School of Public Affairs at American University that's focused on criminal justice innovation and research and reform and policy. And here at JPO, we are getting to grapple with many of the issues that, as a public defender in the courtroom every day, I did not have the agency to address and grapple with the way I wanted to. And through the Right to Counsel campaign, I have the opportunity to get to work on raising awareness about the ways that client Sixth Amendment rights are not being honored the way they should across the country. So I've had the incredible opportunity to get an understanding of what is going on in public defense all over the country, not just in New York City. And through our campaign, we are working to ensure that all stakeholders in the system, like Judge Moore, like Seema Gajwani, that all players are equally dedicated to upholding the Sixth Amendment right to counsel, because, in fact, it's everybody's Sixth Amendment right to counsel. It's not just the people who happen to get arrested. Another great thing about working on the Right to Counsel National Campaign is that it's an opportunity for me to be an advocate for public defenders, which is a community I still feel very close to. And I'm able to advocate for them behind the scenes and work to have them be a part of the national criminal justice reform conversation, which is a conversation that public defenders are often left out of. And it's an opportunity to tackle the systemic problems that that affect the way that public defenders are able to do their jobs the way they want to, such as the heavy caseloads that Judge Moore alluded to, or the criminal court backlogs that still plague jurisdictions like the Bronx. So that is some of what I am working on now, and the ways in which I am still incredibly lucky to be working to ensure the right to counsel through my role as Senior Policy Counsel at the Justice Programs Office. Thank you.
Great, thank you so much, Zoe, and thank you for highlighting the importance of including and elevating the public defender's voice in national criminal justice conversations. As we've seen, criminal justice reform efforts have really started to take taken on a national light, and oftentimes those conversations leave out the voices of defenders. So we love having you on board and to bring that with us. So at this time, we're gonna unmute all of the panelists so that they can answer questions. If you have any questions, please feel free to type them into the Q&A section and direct them to all panelists, and we will get those asked and answered. So I'm going to start with one question that we received, which is, how can young people or other people who have not worked in as public defenders involved? Do people need to first go through a public defense office or be a public defender before they can be an effective advocate for systemic reform? And Seema, let's start with you on that one.
Sure. No, I don't think that folks need to work at a public defender's office in order to be an effective advocate. I do, however, believe that it is important to work with communities that have been directly affected by the justice system in order to be an advocate on criminal justice or juvenile justice reform. I think that's pretty critical. I do also think that it would be really valuable for policy and systems reform people to have both the experience working directly with communities affected by the justice system, and also perhaps in a legislative environment, or in, not only legislative but an executive environment with executive government, or in financing of government programs. I think that there are a number of real important skills that people can bring from different aspects of government to work in systems reform. But again, I think that at the very base, you need to have direct experience working for some time with those affected.
Great, thank you. And Judge Moore, Zoe, does anybody else want to add to that?
I'll just add a little something to it. I agree with everything that Seema said, but I also think that you have to have a strong commitment to making a change, because oftentimes whenever you get involved in an issue that may not be a popular issue, like ensuring that folks have a right to counsel, for instance, you're going to end up getting a lot of pushback at times. And so sometimes it can be discouraging when you're starting out trying to be involved in more community activities, trying to prepare yourself with education and experience to be the best that you can be as far as advocating. And so you got to have that commitment, because you can't fall by the wayside, because in this business we need people who can stay in the trenches no matter what.
Yes. Great. Thank you so much.
Yeah, and this is Zoe. I'll just add that I don't think you need to work at a public defender's office in order to make change. In fact, quite the opposite. We need this change to be coming from all sides, and we need all hands on deck, and the change cannot just be coming from within the public defender's office. We need smart, dedicated, passionate, justice-minded folks in every field of criminal justice reform, so we can make change in a holistic way from all sides.
Great, thanks. And that actually leads quite nicely into the next question that we've received, which is, how do you all personally kind of advocate for the right to counsel among your colleagues who may not see themselves as playing a central role in ensuring this right and who more see it as, you know, I'm just part of the system and this is not my issue, it's the system's fault. Judge, let's start with you.
You know, one of the things that I mentioned in my early presentation, and I had the little cartoon where it dealt with the Constitution and the judge bonking the lawyer on the head. You know, as judges, we kind of feel like we're in our own little world because we're in our own little courtroom, and so we make our own little decisions based on the law, however it's applied. And so, you know, having meetings on a regular basis to talk about the issues of the day, of course that doesn't work, and it's not going to happen. But what I am happy about is the fact that, you know, we've got this system in place right now where the organizations are getting together and then advocating for judges especially to be more informed, more involved. That gives me the opportunity when I speak, when I attend these sessions, when I am a part of it, where I receive information that I can disseminate to my colleagues. I'm not saying you've got to do this and you've got to do that. They already know what they've got to do. And hopefully most, if not all of them, are making a really strong effort and are committed to doing the right thing within the guidelines of the law, within the guidelines of the Constitution. So I had an opportunity with the last conference that I attended to get the report that was prepared, Americans' Views on Public Defenders and the Right to Counsel, and the Right to Counsel National Campaign did a report. And so, Zoe, you actually sent to me about 50 copies that I was able to disseminate to some of the judges, especially those in this county, but some of the judges in the state, and say, here, this is information that you need to look at, you need to consider. And so I think that when we present to our colleagues as judges information that's out there, get feedback from judges, because we have feedback from many of the judges who received it and said, thank you for this information. I did not know that this was out there. It tweaks our conscience to let us know that, you know, if you're not doing this, if you're not concerned about this, if you're not committed to this, because sometimes when we get on the bench, we're on the bench for years, and then we get stale. And so when you get something like this, when you know that things like this are out there, then I'm hoping and praying that it reignites our desire that we had when we started out as public defenders, went way back when we were in law school, and we had this strong desire to just really fight, and we get stale when we're on the bench. So I think that as judges, we need a little fire put up under us sometimes, and I think that this is something that really jumpstarts us to do what we need to do.
Great, thank you so much. Seema, do you have anything to add about how you can talk to prosecutors?
You know, we're lucky because we had strong leadership at the very top of our organization between Attorney General Racine and an incredible deputy of our Public Safety Division, Tamar Meekins, who recently passed away on President's Day, which has been a devastating loss for us. But both of them were absolutely committed to ensuring procedural justice for respondents and defendants in Superior Court in our jurisdiction. And so, you know, when you've got strong political will at the top, it's not hard to impress upon prosecutors that this is of utmost importance. You know, most places don't have that opportunity, and I would just say that there is an effort that is kind of bubbling up. I think it's called Sentinel Events, but there's an effort to look at systems failures in the justice system and then go back and identify where protections or checks could have been put in place to address those failures, and so that the failure didn't happen, and that can be used in the justice system around wrongful convictions. I think, you know, the typical use of that model of reform is in like the healthcare industry or the aviation industry. So where there's a disaster in aviation, they look back and they see all of the ways where there was failure and try and figure out how to prevent that failure. And similarly, around a wrongful conviction in different prosecutors' offices, they're now starting to look at where the failure occurred, and no doubt a lack of zealous representation or strained resources for public defenders contribute to an important failure in our system, where if that was not the case, there would be a more robust check on injustices that could result in a wrongful conviction.
Great, thank you so much. So at this time, we're going to turn it over to April, but if anybody has any other questions, please feel free to send them in the Q&A section and send them to all attendees, and we will get to those questions at the conclusion of the webinar. So without further ado, April.
Hi, good afternoon, everyone. This is April Frazier Camara, Director of Defender Legal Services from the National Legal Aid and Defender Association. So I'm really excited I get a chance to update the group on Right to Counsel National Campaign updates from the field. We're really excited to hear from people in between our quarterly webinars about what is taking place in their particular jurisdiction. So we encourage you all to reach out to myself or Genevieve and Zoe and others at AU and update us from time to time if you have some really exciting work or challenges taking place in your jurisdiction. So we're going to get started, and after I provide the update, we will also open it up to attendees to give announcements and share anything that we did not cover. So we wanted to share recently the National Legal Aid and Defender Association, we partnered with the Association of Prosecuting Attorneys to host a joint event that really focused on the importance of collaboration. And you can see on your screen the agenda from that event that took place on April 10th and 11th here in Washington, D.C. And I was really excited to hear from Seema from the D.C. Office of the Attorney General, because I think she was able to demonstrate from her presentation how important the role of progressive prosecutors are in really achieving the right to counsel and criminal justice reform. And this event was a great event where we pulled together prosecutors and defenders from 4 different jurisdictions to talk about collaboration and specifically how they were working together to advance pretrial reforms. And I wanted to share this with the group because I think as we talk about how to realize some of the goals behind the Right to Counsel campaign, one important strategy is to definitely bring to the table law enforcement and think creatively about how we can collaborate and partner with them around core values that we all share in common around improving the integrity of our criminal justice system, and really making sure that we all have a fairer and more just system. So we can go to the next slide. Also, I'm sure many of you have heard the update from Harris County, Texas. We are really excited to report that the Texas Indigent Defense Commission was actually appropriated over $66 million to focus on statewide public defense reform efforts. And this has been a long fight within Texas, and really a lot of hard work has gone into it, and many of you on the call and who work on a national level know about the right to counsel reforms that really have been taking place in Texas for nearly a decade now. So this was a huge win on the part of the Texas Indigent Defense Commission. So the $66 million has been appropriated, and now it is at the governor's desk waiting to be signed. But our colleagues and consortium members from Harris County definitely wanted to share this really great news with the group about the substantial funding that they were able to leverage for FY18 and 19. Okay, so here, this is more information from the Texas Indigent Defense Commission, and it really shows how over a period of time, how the funding resources have increased. I'm not sure if you can see the image, but they track the defense expenditures in the $1 million category from 2001 to 2016. And so they have been able to see a growth from 2001 from $91 million to the proposed budget of over $300 million for 2017. In 2016, they were appropriated $247 million for statewide public defense. We can go to the next slide. Okay, and this is just more information about Harris County, specifically, and hopefully we will be able to have them on our next webinar where they can answer specific questions. But if you can see here, there was a lot of effort made to be creative in requesting funding, reallocating court costs, in order to generate income to support the right to counsel. And I think this is an important point that we wanted to share with the community, because as we advocate for more resources, we have to think about exactly sources that can fund the right to counsel work, and I think Harris County has done a great job, or the state of Texas done a great job in looking at different streams of revenue to support the right to counsel. Next slide. This is a map that was also provided to us from the Texas Indigent Defense Commission, but it's one that we wanted to share with the group because I think it's a very interesting one to look at the landscape of indigent defense funding. The red states actually indicate states who are fully state funded. And then you see color variations between white, blue, gray, and purple, where there's different diverse state funding and local funding to fund the systems. So we hope that this could be helpful to others in other jurisdictions who are looking at funding sources, and it really gives you a really great national overview of how indigent defense systems are currently funded. Okay, next slide. All right, New York State. This was another major victory for indigent defense. In the state's 2017-2018 budget, they were able to pass a bill to establish standards for public defender services and obligate the state to reimburse those costs of meeting the standards. And also a $250 million amount was given to bring New York County systems, indigent defense systems, up to standard. And as many of you all know, we often hear about practice in New York City, but the state of New York had very stark different realities of public defense systems in the New York City area that are well funded, well resourced, but a lot of the counties in New York State really are struggling, and we see some of them greatest abuses of, as they say, constructive denial of right to counsel. So this was a major victory for the state of New York, and we wanted to share that information with the consortium. Next slide. Okay, so that those are the updates from the field, and specifically the updates that you saw in our presentation are from members who attended our last annual convening, and we receive updates from those people in the field that's going different advancements that's taking place in their local communities. But we also invite you all to share with us any updates that you want us to feature on upcoming quarterly webinars. So Genevieve, I think if you would like me to, we can open the floor up to announcements. If people have any questions about the updates from the field, I'll be happy to answer those as well. But this is also an opportunity for people to give updates from their jurisdiction or ask questions. So feel free to send your questions in by email, and we'll be happy to read those and respond.
Great, thank you so much, April. And again, at this time, I just want to encourage people, if they have any other announcements that they would like to share with all of us on the call, please do so by typing it into the Q&A section on the right-hand side of your screen. And also, if anybody has any other questions for April or for any of our other panelists, please feel free to share them at this time as well. I'm just going to pause for a minute in case somebody is typing, although at this time it doesn't look like there's anything else. I just want to reiterate what Judge Betty Moore said at one point about the report, American Views on Public Defense and the Right to Counsel. It's a really exciting report that we released that, with our partners at Belden Rusinello's Strategists, and it highlights kind of what the public's current level of knowledge is surrounding public defense and the right to counsel, and share some ways that effective messages that communicated the importance of ensuring this right, and you can access that by going to our website, which is rtcnationalcampaign.org. So with that, since there are no other updates at this time, thank you all so much for listening in on this webinar, and thank you again to all of our panelists. It was really great to hear so many different perspectives and to hear the trajectories of all of you, your career paths and how you continue to fight and champion the right to counsel, and we are so happy to have all of you as part of our Right to Counsel National Consortium. So with that, have a wonderful rest of your day. Thank you all so much.